Merci, Monsieur le Président, Madame Vice-Présidente de la Cour.
Thank you, Mr. President.
Myanmar in the first round in 6 points. And I have to say at the outset, it was hard not to be struck by Myanmar's first round arguments, a sort of back to the future of legal submissions. My first point. Mr. Staker addressed the court at length on the issue of legal interest and standing. His position, in short, was that the Gambia has no legal interest in the question of whether Myanmar is treating its citizens in accordance with the requirements of the 1948 Convention. He cited numerous cases in support of that contention, but there was one that he did not mention. As he addressed the court in dulcet Australian tones, I shut my eyes and suddenly wondered if I wasn't hearing the voice of Sir Percy Spender back in 1966, as he explained why he cast the decisive president's vote in favour of the court's conclusion. You will recall that decision, that Ethiopia and Liberia, and I quote, cannot be considered to have established any legal right or interest appertaining to them in the subject matter of the present claims, end of quote. Namely, the question of whether South Africa was treating the inhabitants of the territory of Southwest Africa in accordance with obligations incumbent upon it under international law. That judgment caused a scandal. It cast the court into a wilderness for nearly 2 decades. And this court could, I suppose, if it wishes, rule that Gambia has no legal interest in the case. But you will surely be aware that to take that approach will cast the court into an incomparably more bleak wilderness, given that the overwhelming majority of the members of the United Nations, having endorsed the reports of the UN fact-finding mission and other UN-supported activities, will be truly shocked if this court, 53 years after Southwest Africa, declines to indicate provisional measures in this case. But of course, we trust that that will not be the case. Indeed, I can direct Mr. Staker's attention to a paragraph of that dismal judgment, paragraph 66. Even Sir Percy Spender was willing to accept that if Ethiopia and Liberia had been parties to a treaty, to which South Africa was also a party, which provided basic rights for the inhabitants of Southwest Africa, they would have had standing. Substantive rights, the court ruled, and I quote, may be derived from participation in an international instrument by a state which has signed and ratified, or has acceded, or has in some other manner become a party to it, and which in consequence, and subject to any exceptions expressly indicated, is entitled to enjoy rights under all the provisions of the instrument concerned, end of quote. In the Southwest Africa case, back in 1966, the 3 countries were not all parties to an international instrument like the Genocide Convention, and hence Sir Percy ruled they didn't have legal standing. By contrast, the Gambia is a party to such a treaty, and so is Myanmar. The Gambia has a legal interest, and it has legal standing. My second point, the conditions governing an order for provisional measures. Mr. Staker asserted that on the facts before you, the claim that a genocide has occurred is not plausible. Indeed, he went on, it is so manifestly lacking that the case shouldn't even be inscribed on the court's list. reject the application in limine, he basically said. He followed the submissions of Professor Schabas, who made much of the court's jurisprudence on proving genocidal intent. Understandably, he took you to paragraph 510 of the court's merits judgment in the Croatia case. This states that, and I quote, "For a pattern of conduct to be accepted as evidence of genocidal intent, it would have to be such that it could only point to the existence of such intent. That is to say, that it can only reasonably be understood as reflecting that intent." Let me be clear, the Gambia's application is based squarely on that standard. So are the conclusions of the fact-finding mission and of the Special Rapporteur and of the United States Holocaust Memorial Museum. Professor Schabas said the question you must ask yourselves at this preliminary phase is, and I quote, "whether it is plausible that genocide intent is the only inference that can be drawn," end of quote. It's a reasonable question, provided, of course, that the question is posed in relation to some of the acts alleged, but not necessarily all of them. After all, it is possible for some acts to be characterized as genocidal, such as rape and killing, while others are characterized as crimes against humanity, such as the forcible displacement of human beings or their deportation. If the answer to the question posed by Professor Schabas is yes, in relation to some of the acts that are before you, then you order provisional measures. Moreover, the fact that it is also plausible that another inference could be drawn in relation to those acts does not mean that you cannot order provisional measures. Plausibility is not a zero-sum game. The plausibility of one explanation does not exclude the plausibility of another. Two explanations can be simultaneously plausible. That's a difference between the provisional measures phase and the merits phase. Professor Schabas's attempt to create a new and onerous legal standard at the provisional measures stage, one that imports the test that applies at the merits stage, has no legal basis. Indeed, neither Professor Schabas nor any of Myanmar's other counsel addressed the obligation on Myanmar to prevent genocide under Article 1 and how that interacts with the findings of genocidal intent. As this court is well aware, Myanmar is not only under an obligation not to commit genocide, but also to prevent it, a duty which arises, and I quote, "at the instant that the state learns of, or should normally have learned of, the existence of a serious risk that genocide will be committed," end of quote. UN fact-finding mission reports amply demonstrate the existence of a serious risk. Can this court really conclude otherwise? That seems, frankly, a bit of a stretch, one that would be manifestly inconsistent with the obligation to prevent, an obligation that arises from the first moment of awareness. Yet Professor Schabas tells you that now, today, next week, and thereafter, you are required to apply a standard that requires a conclusive finding of solely genocidal intent simply to be able to order provisional measures. In short, the test at this stage is not whether genocidal intent is the only plausible inference to be drawn, as Professor Schabas argues. If that was the test, it would be hard to see how this court could ever order provisional measures under the Genocide Convention in relation to Article 1, since such a conclusion can hardly be reached without descending deeply into the merits. And that is something the parties agree this court cannot do at this stage. The court did not apply that test back in 1993 in the Bosnia case, although it seems that Myanmar wants you to abandon the approach it then adopted. The thrust of the convention and this court's statute is to require you to act protectively, to err on the side of caution. If it is plausible that a finding of genocide might be made on the basis of the evidence and material that is before you, then you have to order provisional measures. If it is not plausible, then you don't. Given the reports that are on the record, we don't see how this court can possibly conclude that genocidal intent is to be excluded. The agent for Myanmar told you that, and I quote, "Invoking the 1948 Genocide Convention is a matter of utmost gravity," end of quote. Indeed it is. States do not lightly invoke or allege genocide. The fact that 56 members of the OIC have decided to lend their support to this case, along with Canada and the Netherlands, and more will no doubt surely follow, speaks clearly as to the gravity of the current situation. It strengthens the case for provisional measures rather than weakens it, exactly contrary to Myanmar's argument. It is equally telling that a United States federal institution, the US Holocaust Memorial Museum, with a board of trustees that includes 4 members of the US Senate and 5 members of the US House of Representatives, has found, and I quote, "compelling evidence that the Burmese military committed ethnic cleansing, crimes against humanity, and genocide against the Rohingya," end of quote. An institution like this, a venerable institution, does not tend to make public statements that are easily characterized as implausible. Nor, might I add, does Professor Schabas, at least when he's speaking in an academic capacity, rather than as counsel for Myanmar. Let us look at what he told Al Jazeera back in 2013 about the term genocide. And I quote, "We're moving into a zone where the word can be used in the case of the Rohingya. When you see measures preventing births, trying to deny the identity of the people, hoping to see that they really are, eventually, that they no longer exist, denying their history, denying the legitimacy of the right to live where they live, these are all warning signs that mean that it is not frivolous to envisage the use of the term genocide." End of quote. Now, you can watch him on video for yourself. It is publicly available on the web, and the citation is in the footnotes to this speech. Of course, everyone is allowed to change their mind. But the obvious question is, how could that which was not frivolous in 2013, before the clearance operations, before the killings, before the rapes, somehow become implausible in 2019? The path to implausibility is eased, of course, if you simply take certain categories of acts out of the equation. Myanmar has been conspicuously silent, for example, about all the sexual violence that has occurred on a wide and systematic basis. A clear reflection, we say, as do the UN bodies that have considered the matter, of genocidal intent. Yet the word rape, did not once pass the lips of the agent or of any of Myanmar's counsel. There was no commitment to cooperate with UN bodies, no commitment to investigate this crime on its own account, no commitment to prosecute. We heard much from Myanmar's agent about the vital importance of domestic accountability, but not a word about the women and the girls of her country, Myanmar, who have been subjected to these awful serial violations. Madam Agent, your silence said far more than your words. I turn briefly to another point made by Myanmar, the third of my points. You were taken to the recent decision of the ICC pre-trial chamber to authorize an investigation of the deportation of Rohingya from Myanmar to Bangladesh as a crime against humanity, not genocide. You see, counsel suggested, how can it possibly be a genocide if the ICC hasn't said it's a genocide? Well, the explanation is rather prosaic. Myanmar is not a party to the statute of the ICC, but Bangladesh is. And the ICC's jurisdiction only extends to acts occurring on the territory of a state party. No element of the crime of genocide has been committed on the territory of a state party. No element of the crime of genocide has been committed on the territory, no element of the crime of genocide has been committed on the territory of Bangladesh. The crime of deportation, however, which is a crime against humanity, might have been committed on the territory of Bangladesh, as it is a transboundary crime. It is in no way inconsistent with the existence of a genocidal intent in respect of other acts. Indeed, the ICTY genocide cases relating to Srebrenica all also included the crime against humanity of deportation, and Professor Shabas is well aware of their coexistence. Such coexistence of distinct crimes is readily recognized in the jurisprudence of the ICTY, the ICTR, and the ICC. Myanmar suggested that the observations of various bodies, including the High Commissioner for Human Rights and the UN Human Rights Council, that there is ethnic cleansing in Rakhine somehow precludes the plausibility of a simultaneous finding of genocide. That suggestion is wrong in fact and in law. As this court made clear in its Bosnia versus Serbia judgment, it is clear that acts of ethnic cleansing may occur in parallel to acts prohibited by Article 2 of the Convention and may be significant as indicative of the presence of a specific intent, dolus specialis, inspiring those acts. In 2015, the court reaffirmed in its Croatia versus Serbia judgment that, and I quote, acts of ethnic cleansing can indeed be elements in the implementation of a genocidal plan, end of quote. My fourth point, Myanmar made a number of claims about the 1993 orders in the Bosnia case, presumably in response to our argument that those orders are instructive and offer an appropriate starting point for what the court should do in this case. It seems that Myanmar doesn't like the 1993 orders very much. Mr. Staker told you that they were merely a 26-year-old precedent and that they predate the court's important ruling on binding provisional measures in La Grande. But he seems to have missed paragraph 452 of your 2007 Bosnia judgment, where the court stated explicitly that the fact that the 1993 orders predated La Grande, and I quote, does not affect the binding nature of those orders, end of quote, which, I quote, created legal obligations which both parties were required to satisfy, end of quote. Mr. Staker also submitted that the 1993 orders were, in effect, useless, which is my fifth point. Provisional measures in such terms serve no useful purpose. he told you. We are grateful to him for reinforcing the point we made on Tuesday when I reminded you that the 1993 orders failed to prevent the genocide at Srebrenica 2 years later. Provisional measures worded in such broad terms, Mr. Staker explained, make it impossible to know what the precise conduct might be within provisional measures. We agree. The court must go further on the first and second provisional measures and specify with as much precision as possible and on the basis of what has already occurred, the kind of acts that Myanmar must refrain from and prevent. Indeed, to the list we have already provided to you, we would have no objection if you added the acts identified by Professor Schabas in his 2013 interview, like the prevention of births, the right to live where you live, and the denial of the identity of the Rohingya people. On the last point, we noted that the agent said that, and I quote, all children born in Rakhine, regardless of religious background, are issued with birth certificates, end quote. Notwithstanding the UN fact-finding mission's conclusion that this has not been the case, the agent's comment seems to imply, at the very least, a recognition that the Rohingya are human beings, which seems like a concession. But she did not recognize their right to citizenship. And, as you will have noted, and Mr. Reichler reminded you, did not feel able to mention the word Rohingya. We noted, incidentally, that the agent, like her counsel, passed in total silence over the genocide at Srebrenica, one recognized by this court. Perhaps this was because the numbers killed, 8,000, are, in the view of Myanmar, simply too small to merit recognition. After all, as Professor Schabas put it in the case of the Rohingya, and I quote, 10,000 deaths out of a population of well over 1 million might suggest something other than an intent to physically destroy the group, end of quote. But genocide is not just a numbers game, Mr. President, and the Convention makes clear that the intention to destroy a group in part is sufficient. You have evidence before you that entire Rohingya villages have been destroyed, and most, if not all, of the inhabitants have been killed. There is ample authority in the jurisprudence on genocide to support the view that such destruction of an entire community in a limited geographic area on grounds of ethnicity or religion or race, and even where it is not the whole protected group, can properly be characterized as an act of genocide. My sixth submission concerns the other provisional measures we've requested, on which Myanmar had very little to say. On the third measure, they wondered what evidence related to the events described in the application might mean. With respect, Myanmar is assisted by a team of experienced international counsel who can advise them on exactly what this means. It starts with the preservation of mass graves, the preservation of bodies of victims, and the preservation of destroyed villages. And it continues to all the other evidence which presumably is of the kind Myanmar now says it will be gathering for the investigations which they have told the court they are committed to undertaking. The fourth provisional measure, not aggravating or extending the dispute, is standard in the practice of this court. Again, if Myanmar is in doubt, it can obtain advice from its experienced counsel. The fifth provisional measure would impose a reporting requirement, and as Mr. Staker well knows, it is not intended to create some sort of human rights monitoring machinery. It simply requires the parties to inform the court as to the steps they are taking to give effect to the provisional measures orders indicated by the court. This is routine, for example, in matters relating to the law of the sea, which, while of very great importance, cannot be said to be as grave as the issues that arise in this case. If reporting is good enough for the law of the sea, it's certainly good enough for this case. As to the sixth provisional measure, we say it's proper and appropriate for a number of compelling reasons. First, it is intrinsically linked to the obligation under Article 1 of the Genocide Convention to prevent and punish genocide. Effective investigation and the preservation of evidence are fundamental to preventing impunity for genocide and thus complying with the Article 1 obligation. Yet the consistent picture before the court is that Myanmar is refusing to cooperate with or provide access to investigative bodies to collect evidence, thereby creating a material impediment to the eventual punishment of genocide, and that it is itself destroying evidence, including by bulldozing destroyed Rohingya villages. Since Myanmar has proved itself to be unwilling to investigate what has occurred in any real sense, it is only by ordering it to cooperate with independent UN investigators, currently in the form of the Independent Investigative Mechanism, that this court might be able to assure itself that the Gambia's right to have other parties to the convention comply with their Article 1 obligation will be protected pending the resolution of this case. Second, the sixth provisional measure is consistent with the jurisprudence of the court. It builds on the order that was made, for example, in the frontier dispute case. The parties should refrain from any act likely to impede the gathering of evidence material to the present case. Myanmar's persistent refusal to cooperate with UN fact-finding mission has already impeded the gathering of evidence material to the present case. And it's only by indicating the requested provisional measures that further impediment can be avoided. The requested measure is not, as I've said, novel. It's the same in substance as the order made in the frontier dispute case, adapted to the specific circumstances pertaining to this case. Further, it is directly linked to the Article 41 requirement of preserving the respective rights of the parties. It is necessary to preserve the integrity of these proceedings and the Gambia's right to have its claim fairly adjudicated, because this claim will in due course depend on the evidence that can be collected. Myanmar's non-cooperation with international investigative bodies threatens that right, and a provisional measure in the form requested is necessary in order to protect it. Mr. President, members of the court, I will conclude. As I mentioned in my first round statement, genocide is not a single act. From its very genesis, it has been recognized to be a continuum. That was the only point I made in invoking the spirit of Dr. Lemkin. And it is comprised of different actions, which individually and together, and over stages and time, amount to this most heinous crime. With genocide, one thing always leads to another. That was the point of invoking the spirit of Primo Levi. The situation the court is confronted with today is a delicate one. Unlike in the Bosnia case, there is no international criminal tribunal with special responsibility for the crimes committed in this case. Today, the hopes of the Gambia and of the Rohingya people, some of whom are in the Great Hall today, rest entirely with you to exercise the power vested in you by Article 41 of the statute, and to grant specific, protective, provisional measures to interrupt and prevent the continuum of genocide, to break the chain that has already occurred and is continuing to occur today in Rakhine. Myanmar urges you to take a different path. Peace and harmony is best assured by doing nothing. the agent told you yesterday. Forget about the 1993 orders, Council said yesterday. They're useless. Go back to the glory days of 1966 and the Southwest Africa judgment. Council, in effect, pleaded, but not its paragraph 66. And forget about the Genocide Convention of 1948. Just give Myanmar the space and the freedom to act, unfettered by the unfortunate distraction that is international law. Perhaps some of you might be tempted to do that. But we trust that the court will exercise its judicial function, that it will apply the law, that it will give effect to the requirements that the drafters of the 1948 Convention entrusted upon you, and that you will not abdicate your judicial functions and responsibilities. Mr. President, Madam Vice President, members of the court, the eyes of the world, of individuals and of groups, of countries and of United Nations bodies are upon this court. That concludes my submissions. I'd like to express my thanks to all my colleagues for their assistance, in particular Ms. Jessica Jones. I thank you for your kind and patient attention and invite you to ask the agent of the Gambia to the bar.